Hello friends, welcome to CIPCT Patent Academy. Welcome to a new video. In this video, we'll deal with sections 11 to 14 of Indian Patent Act. So starting with section 11. So section 11 deals with priority dates of claims of a complete specification. So as you know that a complete specification has many claims, and each of these claims has a respective priority date. A claim can have one or more priority dates. So this section deals with the aspects of the priority dates of claims. So subsection 1 says that priority date for each of a claim of a complete specification. So each claim will have a priority date. Then subsection 2 says that a provisional application or a specification which has been which is under subsection 3 of section 9. So you would remember that subsection 3 of section 9 says that a complete specification when it is converted as a provisional specification. So it's talking about that particular section. It says that the priority date of that claim shall be the date of the filing of the relevant specification. So if you want to find out the priority date of a claim, so find the date of filing of that particular specification under which that claim is written. So this is the best way to find it out according to this subsection. Subsection 3 deals with when a specification is filed with two or more applications. So what will be, the how to find out the priority dates of these kinds of applications. So when two or more applications are accompanied by such a specification, so what will be the priority date? So under A you can see that in one of those specifications, the priority date of that claim shall be the date of the filing of the application accompanied by that specification. So basically the priority date of that claim will be the filing date of that particular application, the same that we discussed in the previous subsection. Then if the matter is disclosed partly in one specification and partly in another, the priority date of that claim will be the date of filing of the application of the later date. So if there is a claim whose matter is disclosed in two or more applications, specifications you can say, and it is partly in one and partly in other, and you need to find out the priority date. So how will you find the priority date? Will be the date of the specification of the which is falling later. So these kinds of questions are asked in the objective type questions. So it's very essential to memorize these clauses, that if it is partly in one partly in another, so the priority date of that claim will be the date of filing of the later date. Then if a complete specification is based on a previously filed application in India, so the priority date will be the date of the previously filed application in which the matter was first disclosed. So the best way to remember is, if you want to find the priority date, it is always the earliest one. So the previously filed application's priority date will be considered in such cases. If the claim is fairly based on a matter disclosed in any of the earlier specification, provisional or complete, the priority date of that claim shall be the date of filing of that specification in which the matter was first disclosed. This is with respect to the divisional application. So here also the earliest priority date will be considered. Yes. Subsection 5 deals with any claim of a complete specification would have two or more priority dates. The priority date of the claim shall be the earlier or earliest of those dates. Then subsection 6 says that the priority date of a claim with respect to the provisions of 137 be the date of filing of the complete specification, under post dating and antedating of the applications under section 9 or section 17 respectively. So in those kind of situations, a reference to the date so as post dated or antedated will be considered. Subsection 8 says that a claim in a complete specification shall not be invalid because only of the reason because the publication or use of the invention so far which is in that claim on or after the priority date of any such claim. So if somebody else has published or used that invention after the priority date of such claim, so it will not be considered as invalid, or the grant of another patent which claims the invention so far claimed in a claim of same or later priority date. So the priority date of the present of our invention of the present invention is earlier than that of the another patent which also talks about the invention. So these are the clauses. Also with regard to the amended specifications, if like you have got a first FER and you made some amendments in the claim, so after making those amendments, when the examiner will check, so he'll consider those amended claims and then make the report with respect to the anticipation, which is which will deal with section 30. Subsection 11A is very important. It deals with the publication of applications which is done within 18 months from the filing or the priority date. So within such period means 18 months. So what happens is when you have filed the patent application, so within 18 months it will not be published, will not be available to the public, but after 18 months it will be available on the patent office website. So and the abstract title or the claims and some details will be published so that it's available to the general public for scrutiny. So this subsection deals with this clause. Then the applicant may request the controller to publish the application at any time before the expiry of this period, that means 18 months, and subject to the provisions of subsection 3, the controller shall publish such application as soon as possible. So if the application is not abandoned or withdrawn, the controller will publish it. So and then we come on to subsection 3. This is very important. So there are 3 subsections under which your application may considered to be withdrawn, to be abandoned, all these things are imposed in which it is will not be published. So these clauses are where secrecy direction is imposed under section 35. If it is abandoned under subsection 1 or section 9, that means you have not filed the complete specification within 12 months of filing the provisional application, or it has been withdrawn 3 months prior to the period specified under subsection 1, that is 18 months. So if it is like within 15 months the application has been withdrawn, so under these circumstances your application will not be published. This is often asked in the objective type questions. Then in case of secrecy direction is imposed under section 35, then it shall be published after the expiry of the period prescribed under subsection 1, that is 18 months, or when the secrecy direction has ceased to operate, whichever is later. Okay. Subsection 5 deals says that the publication of every application under this section shall include date of application, number of application, name and address of the applicant, and an abstract. So these are the details that are published. Then with related to the biological material, so the depository institute shall make the biological material that is mentioned in the specification available to the public upon the publication of the application. Then the patent office on payment of some fees make the specification and drawings, if any, available to the public on or before the date of publication of the patent and until the date of grant of the patent, the applicant will have the like privileges and rights as if it had been granted. So however, he will not be entitled for any proceedings, for any suit for infringement until the patent has been granted. So this is very important to remember that your privileges, your rights will start from the date of publication. However, you can apply for infringement proceedings or suits only after the patent is granted. So many times questions are based on these clause. So it's very important to remember these fact. Yeah, then again all these things are described in the further subsections, that you will have the uh, right privileges from the date of publication. You can if you have some product, you can mention patent applied, patent pending, or the application number you can write there. You can write it on your products and mention that it is it's under the process, and when it is granted, then we write it as patent and the patent number. So then we can sue after getting the patent granted. We can sue anybody who performs an infringement of our patent. But before that, we have the right and the privileges. So even if some person is infringing onto our patent, so we can indicate that person that we have filed for the patent and it's patent pending. However, but if it is granted, so the person will be liable for an infringement, so he should stop performing that infringement activity. Subsection 11b deals with the request for examination, another very important subsection. It says that no application shall be examined unless the applicant or any other interested person, so remember this as well, makes a request in the prescribed manner for such examination within the prescribed period, and that is 48 months from filing or priority date. So the particular form, you have to fill it up, and you have to apply for the examination. Then only your patent will be examined, unless it will be considered as abandoned. Then the same thing, that if you do not that is written in subsection 4, that if the applicant or any other person interested, the interested person does not make a request for examination within the 48 months of the period, the application shall be treated as withdrawn by the applicant. Yeah. And in case of a secrecy direction has been issued under section 35, the request shall be made within the prescribed period from the date of revocation of the secrecy direction. Section 12 deals with examination of application. So after the request for examination has been made with respect to the application, then the application and the other documents like forms, the PUA or the other documents are referred to the examiner by the controller. So the case is transferred to an examiner by the controller, who is going to check the documents. He is going to see whether the application, the specification and other documents are within the requirements of the act and the rules as well, and whether there is no ground of objection related to the grant of the application, that all the formal requirements have been done, there is no anticipation with respect to a prior art. That is the investigations made under section 13, and any other matter like any other documents that are described here. So that is, the formal requirements are met or not. Section 13 deals with search for anticipation by previous publication and by prior claim. So this is very important. This is also very important aspect of objection of an application by the examiner. So the examiner, when an application is referred to him under section 12, he will make an investigation with respect to anticipation by any previous publication or by prior claim. So previous publication can be any document, any oral verbal statement, or any written document, any non-patent literature or a patent literature, anything. So it sees that whether the any claim of the complete specification has been anticipated by publication before the date of filing of the applicant's complete specification, and or if it is claimed in any claim of any other complete specification which is published on or after the date of filing of the applicant's complete specification. So the publication date and the date of filing. So he will match it with the date of filing of the applicant's complete specification and see whether these prior art documents are before the date of filing of the applicant's invention, or if it is later. If it is if it falls before, so the uh, it's likely to get objection on anticipation. Then subsection 2 deals with that the examiner shall make an investigation and ascertain that whether the invention is claimed in any claim of the complete specification has been anticipated by publication in India or elsewhere in any other document other than that which is mentioned in subsection 1 before the date of filing of the applicant's complete specification. Subsection 4 says that the examination of the application by the examiner, by the controller, under section 12 does not warrants the validity of any patent. So basically it can fall under post grant opposition or pre grant opposition. So any person may oppose it and contest the invalidity, may find some prior art reference or some any ground of objection which might have skipped from the controller. So that is possible. So this subsection deals with that. So it does not warrant the validity of any patent. Section 14 deals with consideration of the report of examiner by the controller. So this is very easy. It says that after the report of the examiner has been made, it is sent to the controller. He sees the the report, and he if it is adverse to the applicant, or if it requires any amendment or in the specification, or any if it requires any other documents, any formal requirements, or any compliance with any other provisions or rules, the controller will tell it to the applicant. He will initiate a hearing with the or as a FER to the applicant before disposing of the application, and it will send the the objections to the applicant within the prescribed period, and also give him the opportunity of being heard. Then I have put up few questions from the previous year's question papers. So you can go through. The green highlighted clauses are the correct answers for these questions. Please like, subscribe, comment and share our channel Patent Academy, and also please provide your valuable feedback. We'll be back with more videos. Thank you.